James, as she comes out, Your Honor, this is a bond revocation issued by EMU when the court's ready.
I am.
Thank you, Judge. I represent Ms. James before Judge Mallory. She is has a court date coming up in November. She's on EMU. She has time out, and this is a strange revocation. It alleges that she was in stores. She wasn't stealing. She during her quote unquote time out for job, looking for job. She was out for normal reasons. She had something called a PRC card from Jobs and Family Services, where she was purchasing items. When she found out about the warrant, before she emotionally contacted me, she turned herself in yesterday. I contacted Judge Mallory. He says, we'll sort it out in court. I'm asking that you reinstate it. Was not for any new criminal offense, but only her GPS monitoring showed her she was at a store, at stores, and she was informed by the EMU officer, this supervisor, that she was not to be in any stores. Not aware of that. That's an issue for Judge Mallory. We're asking that you reinstate the bond.
Is there anything from the state?
Judge, it looks like she was in stores that were 36 and 48 minutes from her home. So not nearby. Marshall's, Kohl's, Burlington, Walmart, City Trend. Is where they're showing her going.
There were no new offenses. I will reinstate the original bond. Ms. James, when they put your EMD unit back on, make sure that you ask them what your limitations are. They will tell you what the limitations are so that you know the parameters that you need to operate in, okay?
Thank you, Judge.
Reinstate the original bond.
Have a good day. Thanks, guys.
Next will be Fout, Tyler Fout.
He's waiting. Morning, Judge. He had to go back upstairs.
Okay.
He, for the record, made probable cause. He's being held on another case. If I could have a nominal bond, please.
From the state.
Your Honor, Mr. Fout is already being held on other matters, is my understanding. He looks like spit on an officer, on EMU officers at the time of his arrest. We would request HIV, tuberculosis, and hepatitis testing as part of any bond. I know the court is familiar with Mr. Fout. He does have a pending case in front of Judge Mallory, or excuse me, he looks like he wrapped that up last month.
He's on misdemeanor mental health court.
$20,000 anyway, plus infectious disease testing.
Judge, this will come back 11/7. Walker? Got Walker? I'm showing this as one count of assault.
And Your Honor, please not guilty. As the bond, Mr. Walker, he had originally had a recite court date for today. I believe that's why he's here this morning. It was originally a walk-in for 12:30. Mr. Walker, he is being held on felonies, and speaking with him, he does want to ask for an LR. I would just note that he does work for SDNR Construction. He has 4 children that typically live with them. Right now they're with their mother, but it is his son's birthday on Sunday. We're just asking for an LR.
From the state.
Judge, it looks as if he has 5 counts of felonious assault pending. Those might be awaiting a grand jury report date, either or next week, early next week.
Are those charges against the same prosecuting witness?
Judge, at this point, I do not know that information. Apologize. I think as I recall, it's against multiple people, 5 different individuals. It does appear that this occurred on 5/10.
It looks like Mr. Walker is being held on $500,000 in bonds on the other cases. The $5,000 anyway, plus juris if requested.
And that'll go to the assignment commissioner.
Let's see.
Smith, which this is off the 10:30 docket.
We're waiving Ms. Smith's
Smith?
appearance.
No, actually,
Oh, she's
Judge,
here?
this is one who is coming out. I've been able to talk to her. Anybody here on Mariah Smith? Judge, the felony was ignored this morning, and the only remaining charge is in obstructing official business. And her bond is $10,000 at 10% on that second degree misdemeanor. I don't think there's a Marcy's Law concern because of the charge, and I'm wondering if the court would reconsider the bond. Ms. Smith reports a stable address of 1086 Pine Hollow Lane, where she lives with her mother and family. She's been in this area her whole life. She graduated from Sycamore High School. She found out while she was in the jail that she was promoted to shift lead at Duncan, and so she believes she still has that job. Judge, I know the felony involved a gun, and so just anticipating the court's concern, Olivia Henniger from our Adult Social Services Division went back and spoke with Ms. Smith, and thinks that she's in a good place, but I think there's going to be an ongoing referral with our social services department.
Do you receive treatment through any agency right now?
No, I'm not.
We'd ask the court to consider a lower bond or even a supervised OR bond, Your Honor.
From the state?
Your Honor, the felony has been ignored. That was involving some concerning behavior, as I know the court is aware. The obstruction is when officers were attempting to place her into custody for that. She attempted to pull away and also prevented handcuffs from being applied to her. It looks like they did recover a handgun from the bedroom as well.
Ms. Smith has, as an adult, 1 minor misdemeanor, 2 prior failures to appear, no other offenses, no acts of violence. The bond will be OR plus EMD. I am putting the EMD on because of the prior failures to appear and to monitor your compliance with the recommendations of the Social Services Department. All right, so also as a condition of bond is to comply with any mental health recommendations. All right, thank you.
Thank you, Judge.
Jeremy Evans.
Good morning, Your Honor. Lindsay Arway here on behalf of Mr. Evans, entering a not guilty plea.
All right, as to bond.
As to bond, Your Honor, Mr. Evans has an ORIS score of 1. He is currently employed at Blinds Warehouse as a manager. He is local resident, has been here since all his life, graduated from Norwood High School, has no prior failures to appear. I don't see any significant prior history with the exception of robbery from 10 years ago, but nothing since then. He does not have a history of violating any protection orders or any prior protection orders to the best of my knowledge. We would be asking that the court consider granting a low bond in this case.
From the state.
Your Honor, the allegations include that he violated the order by arriving at the protected person's house. He's honking his horn, he was yelling, and then drove through the yard and damaged a landscaping light. Looking at his record, he does have a prior from 2015, 2016 of aggravated robbery with specifications for which he served time in the institution. This order was filed on 9/12 of 2025. We would respectfully request monetary bond as well as juris if requested by the prosecuting witness, and then he is under a disability.
There's not been any allegation of a firearm having been used, Your Honor, so with the disability, I think he's prevented under the law from being in possession of one anyhow. No objection to that being an order of the court.
There was no allegation of a weapon used in this offense, and as has been stated, he's already prevented by law, so I'm not going to put in place a separate order on this case. The bond is $10,000 anyway, plus juris if requested.
Thank you very much, Your Honor.
Thank you, Your Honor. Judge, I don't believe there are any standalone DVs for the city.
All right.
I think they're all maybe attached to the, when we come back, Berg will be next. Emily Berg.
She's being waived again today.
How are our 10:30s?
I think we're pretty much done. I mean, we're not pretty much done, we are.
We're on time. Perfect. Yeah, I got quite the stack of felonies. The misdemeanor thing is bad. Yeah, I saw several where there are some older. Right.
I mean, a lot like that. And then any other city that's just with no attached. But yeah, there's a few.
If for some reason we close the house.
We've got the A.
I've got the A, but
We
yeah.
have some private. Did anybody know violations?
Some of those traffics may be related.
I know, I bet.
Yeah.
We'll just make sure. That's us. Stand here. It's not. It's not boring yet.
Some session.
Whenever we thought we were.
Grand jury.
Are you, yeah.
Yeah.
To ask something like, would you?
Probably,
Misdemeanor, because it looks like felony
no.
to us.
oh,
You don't go to you
if
for
you,
We have some
no,
other
you-
people we
yeah,
talk
that would go to grand jury, and they would say, send it over. Like, 512.
You-
Yeah.
people. Tighten up the advanced processes and communication. So I was like, we really need to do that.
Secret.
Yes. Rather than TRC at all. Because that just-
They
that's
can
just
still,
all
they can still rent the mud.
clerk numbers anyway, right?
And I think that's a conversation between at least the entities, between police, us, and the clerk's office.
Yeah.
How to do this. I think everyone's got more.
Oh, tomorrow.
Court is back in session.
Your Honor, we're going to go back with Emily Berg. My understanding is that her presence is being waived this morning.
That's correct. She is still sick. So I know that we continued it yesterday. We're hoping to be able to just assign somebody tomorrow.
So do you want this set over to
Yes,
tomorrow? Or
10:31.
continue to October 31st at defendant's request at 9 a.m., no bond.
Rondell Carr.
For the record, Your Honor, Dan Might standing in for James Costin. Moved to waive his appearance, Your Honor. He already has counsel on a pending felony. Waive probable cause and asks to be heard on bond when the court's ready. Judge, there is a pending charge, and it looks like he's been in the Justice Center since October 4th, so almost a month. He hasn't been able to make at least one of the bonds that have been set. You're setting bond on a third-degree felony and a fifth-degree felony. We'd ask the court to set a bond commensurate with the level of the offense.
From the state.
And Judge, it appears that that's correct. He's being, his pending case is the exact same charge, and this has been filed. He does have a history indicating robbery, drugs, and a significant solicitation history.
Judge, just to clarify a little bit, you can probably see this is from August 8th, so I'm not sure why it was just filed yesterday, but it doesn't look to be recent behavior.
Are these add-on cases to the cases that are pending?
Judge, no, the cases that are pending, I think, came in September.
No, those are-
Early October. 10/4, I'm showing as an arrest date on the prior case that's assigned to Judge McDowell.
Is it though
And
the same date? Like these are from August, but
Right.
it's filed today?
Right.
Because they're the exact same charge.
right, I do not think, I don't know if they're the same date. I think it represents a separate situation.
I will say, Judge, that this looks like it was a sting operation. It looks like there was an undercover officer.
That's
So that sometimes that explains why there's a delay.
It looks like he was served in population.
There are 3 prior violent felonies, 3 felonies, 29 misdemeanors, 2 prior failures to appear. Bond is 10,000 anyway on each count.
11 for grand jury, Your Honor.
What was that again, Your Honor?
11 counts.
10,000 anyway on each count.
Conlon, F5, possession of drugs and public indecency. Looks like this is out of the same event.
They go together, Judge. Ms. Cox, for the record, will waive probable cause. Yes, you heard us, Devon.
Ask Bond.
Judge, Christopher's local to the area. He takes care of his father, and he has been doing so for the last year and a half. Unfortunately, he's disabled. Dad owns his own condo, and my client lives with him. He also has his child part-time, half-time specifically. He and mom have a shared parenting agreement with each other. I would ask Your Honor to consider giving him an OR bond. This is at least the felony allegations in F5 level. There is probably going to be a probable cause issue related to the stop surrounding the misdemeanor. But obviously a very low level drug allegation. We are asking for an OR bond, Judge.
From the state.
Judge, I do show a prior felony history. In this case, the drugs involved are methamphetamine, and the public indecency is apparently he was observed pantsless, and then in his interaction with officers, admitted to engaging in masturbation in the park.
For the record, he wasn't found pantsless in public. He was found pantsless by the officer in his own motor vehicle after the stop.
Is this case going to drug court?
He is eligible for drug court, yes, Your Honor.
There are 4 prior felonies, 3 misdemeanors, 0 failures to appear. These are non-violent offenses. It will be supervised OR on the misdemeanor of the 4th degree and on the F5 possession. I am adding random urine screens as a condition of bond.
Thank you, Your Honor.
Judge, we would ask that he stay out of the parks.
No problem.
And let's stay away until the case is resolved from public parks.
And that was a straight OR, correct, Judge?
Yes.
1113. Horns?
Your Honor, for the record, Dan Mites standing in for Darceny Winston. And Judge Wolf moved to waive her appearance. She already has appointed counsel on a pending case, Judge. In fact, Ms. Cornez was before you yesterday, and you set a bond that will allow her to go to First Step Home.
I put her on EMD lockdown, the first step home.
Judge,
Yes.
Your Honor, this is catching up from yesterday. She had a conveyance charge. It relates to the conveyance charge. And we already have a grand jury date for that case of 11/7.
So we're waiving probable cause on this.
Yes, we are.
This will be the same as the others. It's OR plus EMD lockdown to First Step Home for treatment. All right.
Thank you.
Thank you.
Cornett?
Yeah, you're turning on the other way.
And Your Honor, we're not waiving probable cause.
was the date on Horns? Was it 11/7?
11/7, yes. Judge, as to the probable cause on the felonious assault, is that the defendant on or about the 29th of October 2025 in and from Kansas State to knowingly cause serious physical harm to Chantel Arnold, that by biting the victim and was knowingly positive for HIV. Looking like the defendant came to the victim's residence. Her spouse had to open the door, and it took him too long, and he was upset. He pushed her partner to the ground, grabbed her by the hair from behind, and it led to a physical altercation. He bit her, and he is HIV positive and has been the aggressor.
Your Honor, if I may be heard.
Yes.
Under the statute, in order for the F2 allegation, for there to be probable cause, there has to be some sort of sexual contact alleged. That's what's required under the felonious assault statute. So we would ask Your Honor to not find probable cause, treat it as a misdemeanor when addressing bond.
Is there any response from the state?
Judge, give me.
I have this charged on the complaint under Division A, but the Division B addresses knowing that a person is tested positive.
And I think the B subsection relates to an individual who lacks the capacity to appreciate when an individual has indicated that they are positive. That is the specific language in the B subsection. I agree with you, Judge. Obviously, the charge is under the A subsection. Sexual contact is what's required. I don't think the state's met its burden.
Judge, I think the A section is what deals with the serious physical harm, certainly causing or attempting to cause serious physical harm by potentially transmitting HIV or other communicable diseases would qualify. We respectfully ask that PC be found.
Based on the subsection that is charged under, the court is finding that there is probable cause. As to bond.
As to bond, Your Honor, Gerald is a high school graduate from Coleraine, originally graduated in 2016. He would like to go back to school. Unfortunately, he's not working. He does experience some extreme and severe depression. His mom died 3 years ago. He and his brother and his younger brother and his older brother all owned this house together. They were deeded this property. It was his mother's originally, and it was left through her estate to these three boys. He has no problem staying away from this property, but just so the court's aware, this was an allegation that arose in his own home. We are asking, Your Honor, to consider giving him an OR bond. We would ask that Your Honor also consider allowing him a police escort to go back to the property. He was there the other night to go ahead and get his medication in his car so that he could reside outside of that home until the issues resolved surrounding this individual. He does have somewhere else to stay. Like I said, does experience some depression and obviously has some physical health issues. He does treat with Christ Hospital, sees a doctor every 6 months, has his labs done every 6 months. I am asking Your Honor to consider giving him some sort of OR bond.
From the state.
Your Honor, it appears that he does have two prior failures to appear. So we would ask that that be taken into consideration. And the nature of this conduct where potential harm to the victim is great. It also asks for no contact and stay away.
What is the relationship between the parties? I have a roommate on here, are they family members?
So the individual who is disabled per the affidavit, that is my client's brother. So my understanding is that maybe this is brother's partner.
Mr. Cornett has no record at all as an adult or juvenile. It looks like the two failures to appear arise out of traffic incidents. This is a felony of the second degree. The court found probable cause to hold. But the allegations and the level of the offense barely meet that. This teeters on, as defense counsel had argued, a misdemeanor, but it's not at this stage up to the court to weigh the actual evidence and just to look at the allegation, which for felonious assault, what it is charged as is to cause serious, the subsection is to knowingly cause serious physical harm to another or to another's unborn. I understand the allegation that he knowingly bit someone and was positive, but it was not charged under that, the B subsection, dealing specifically with someone who is knowingly positive for a virus. Based on that, the bond will be OR. I am going to put an EMD on it because of the two prior failures to appear. And I want to make sure that outside of going to the home to retrieve personal items with a police escort, that Mr. Cornett, until further order of the court, does not go back to that property. So you can go and get your personal items, but after that, you cannot go back. All right?
11:10. Jalen Crawford.
OR plus EMU.
Your Honor, I'm submitting Edel Gray's designation for Mr. Crawford.
Bring them together right now.
The felonies are appropriate for drug court. We'll waive probable cause. Has to be heard on bond.
Esteban.
Mr. Crawford is 20 years old. He has been in the greater Cincinnati area his whole life. He graduated from Don Community High School. Reports being employed at Walmart. I believe these are 3 fifth-degree felonies, and he is going to be offered treatment, Your Honor.
From the state.
Your Honor, looking at his history, it seems limited or non-existent as an adult. However, he does have a juvenile record for failure to comply in OOB. It's somewhat recent, from 2019. I looked at that due to his young age. The drugs involved here are fentanyl, and then he conveyed that same narcotic into the Justice Center. And he also indicated that to officers that he sells marijuana after being Mirandized.
Mr. Crawford, is 20.
As well.
He has no record at all as an adult, no failures to appear as a juvenile because of his age. Even looking at his juvenile record, there are 3 misdemeanors, none of which involve drugs. These are all F5s
Yes.
that are eligible for drug court and pursuant to the complaint under bulk amount and for personal use will be a supervised OR plus random urine screens.
Judge OR the traffic.
Yes, traffic is OR as well.
1113.
Thank you, Your Honor.
Left hallway, Live. Muhammad. Giselle.
Atia L.
You're turning it, but the way now.
Can we have a probable cause?
Wait, probable cause, Judge.
Esteban.
Asked to bond, Miss L lives here in Cincinnati. I have a good address and phone number for her. She has 3 children, 24, 21, and 14. I see no violent adult convictions whatsoever. She does work full-time for Crown Staffing. She does binding. She takes care of her mother who is disabled. She's the guardian for her mother. This allegation is from October 7th of 2025. My understanding is that she was arrested. She was in the presence of the gentleman that's the prosecuting witness in this case. I think that they've had contact since he put these allegations out on her. She was very surprised that there was a warrant out for her arrest.
Judge, the allegations include that the PW and the defendant are known to each other. The defendant entered the victim's residence once he left, removed a TV and a video game system. Looking at the additional materials, it looks like there is there was a witness who was also interviewed by police, stated that witness stated that he observed the defendant wearing a beige shirt, black pants, while carrying a television and a PlayStation console from that residence. He saw her load those items into a blue SUV, was shown a photograph of the defendant, and he positively identified her as the individual that he saw doing that. It appears that the victim in this case, or PW in this case, also seemed to think that there are some gambling issues and that these items were taken to sell or pawn for money. Looking at her record, it does appear that she has at least 2 felony thefts
Judge, can I add one more thing?
Yes.
You're done. Judge, these two people share a child. They share the 14-year-old child. She has since had permission to return to that residence. I ask the court to consider that for them.
There are 2 prior felonies, 1 misdemeanor, 0 failures to appear, no offenses of violence. This is a felony of the 2nd degree. The specific allegations are going into the child's father's home and taking a TV and a video game without his knowledge or consent. Where was Miss L arrested at? Not at the place where this allegedly occurred.
That was a traffic stop where I believe he was the driver.
And this is from October 7th.
That's correct.
Supervised OR plus jurors if requested. So they will contact the prosecuting witness prior to release.
And then stay away, no contact.
Well,
Well,
I'm
I know
putting
there's
jurist on, so if he wants the jurist, then the stay away, no contact will be automatic. If he doesn't want it, then I won't order it separately.
Judge, grand jury will report on the 10th of November, 11/10. Belinda Green, ready?
Your Honor, for the felony, I'm submitting a Del Grace designation, and then Ms. Valentix on the unrelated misdemeanors. But we'll waive probable cause. Your Honor, with respect to the felony, she is 56 years old. I know a significant misdemeanor record, but I can't see any felonies. She's a lifelong resident. She reports to me that, or she has reported to us that she is connected with Greater Cincinnati Behavioral. So I know that that's going to be helpful in communicating about court dates and so forth. And she is going to be offered treatment, Your Honor.
And I'm sorry, did you say you waived probable cause?
Yes, Judge. I think this might have been an arrest on a warrant, but we'll wait.
Did you have anything you wanted to add?
Not guilty on the misdemeanors, Judge, and yes, she did indicate that she's been with GCB for the past 5 years.
From the state?
Your Honor, as to the felony, and only that felony will go to grand jury, the rest will go back to the AC. It's an F3 possession of meth. Looks like officers made contact with her, recovered the powder, sent it to the lab, and it came back positive for meth, 7.06 grams.
If I may, from the city, just with the KPS history, please make sure she's coming back for court on these.
Did you want to add anything else? Is that it? Okay.
No, thank you.
If the KPS bonds are the same, do you want a nominal bond on this possession?
Yeah, yes.
It would be 500 anyway on the possession. On the misdemeanors, as counsel stated, there are no felonies. There's 1 violent misdemeanor, 39 misdemeanors, and of more concern was setting bond, there are 81 prior failures to appear in the past 5 years. But Judge Johnson is her trial judge. He has set bonds, and I will keep his bonds. He knows Ms. Green better than I do, so I will keep the bonds that he set on his cases, and they'll go back to their, he set those at 1,000 anyway.
Thank you.
Judge, 1110 for grand jury, Jordan Harris. There is a request for an order of protection. Jody Cunningham. If you're present in court, please come forward and show your ID to the deputy.
We would waive probable cause and send our deputy, please. Your Honor, as the bond, he is currently executing the temporary protection order. He does have no place he can stay. I see an early score of 1, 0 failures to appear. Sorry, very minimal record with no offenses of violence. Other than that, Judge is employed as a full-time manager, father of 2 kids. He's got a lot going for him. He doesn't have, like I said, a stable address or active contact information for him. I would be requesting that SOR bond, Judge.
Your Honor, it looks as if the victim indicated police that the defendant strangled her, punched her, and they are boyfriend and girlfriend who reside together. In reviewing the materials that I've been provided this morning, there is a concerning fact that there's an indication that he had a gun during this episode. When he left the scene and he was being pursued by police, he told the officers the gun was at his home by the couch. Officers found a witness that said that they had a video of the defendant actually throwing it under their deck. And they went back and recovered the gun under the deck. So we do have concerns about the presence of a firearm in this particular instance. And we would respectfully request a monetary bond, jurors have requested, and no firearms.
Your Honor, obviously, none of the paperwork I have says anything about a firearm at all. It certainly seems like a very important thing to leave out. It's not listed in the 527 anywhere in the affidavit or complaint. Nor was he charged with any, charge relating to a firearm.
As was stated, as an adult, there's no record except for 2 minor misdemeanors, no failures to appear. The allegations, though, are serious, allegations of strangling and punching multiple times. On the safety questionnaire, the prosecuting witness completed and said that she does not feel safe in the home. The officer's portion, this may be where the handgun came in, because the officer filled out the portion and listed the visible signs of physical harm, which included swollen eyes from the alleged punching and scratches on her neck, and that they believe the alleged perpetrator had a deadly weapon, specifically a handgun. That's the officer's portion filled out on the questionnaire. On the misdemeanors, those are charged in the alternative, correct?
Yes, sir.
Those are 10,000 anyway, plus juris if requested. On the strangulation, 20,000 anyway, plus juris if requested with the TPO.
So grand jury,
Grand jury will be 11/10. Hemphill, Darren Hemphill.
sorry.
My understanding, he was taken back up. I'll make his appearance for today.
Do you want to set it up till tomorrow? You can set it up.
I currently represent him on another case, so I'm comfortable.
This
doing
might be
both.
related.
It-
Looking at the defendant.
It's related to a misdemeanor that's pending. We had to call Central Lawrence and tell them that it was floating out there in the ether. No one could find it. So he's finally been served. I represent him on another case.
This is the cases with Judge Greenberg.
Yes, which are unrelated, I think, to his 2025 felonies I represent him on. But he is being held on other cases. I'd ask for an hour.
From the state.
Judge, yeah, I noted the pending felonies, and looks like the court has available to its record. I won't go over that.
He already has substantial bonds of about 100,000 almost, so I'll put nominal bonds on these, 1,000 anyway. Is there somewhere on the receiving stolen property that should be a stay away, no contact?
Judge, it looks like there is a named victim in the complaint, the owner of the motor vehicle. And we just asked to stay away from that
Stay away
individual.
from PW.
And then the grand jury will be 11/10.
Thank you.
Daquan Jones.
You know, we would request probable cause, reading of probable cause
Like everything or?
on the, well, I guess all the firearm charges, yeah.
Okay, so that is the case ending in 19119.
Yes.
That Daquan Jones, on or about the 29th of October 2025, did knowingly have a firearm. He was in possession of a loaded Palmer 80, which is a 9mm firearm. He has a prior conviction for robbery, and they have felony warrants for drug possession. It looks like those had been indicted at that point as well. The arrested had that loaded firearm and is prohibited from that. It looks as if the improper handling, and this is all the same firearm, same instance, the improper handling is within his reach or accessible to the operator passenger. Specifically, that same Palmer 89mm was in the back seat of the vehicle where he was seated. And then as the CCW judge, he had that loaded 9mm firearm, and he is an unqualified adult because of his prior convictions.
Your Honor, it's my understanding, speaking both with my client and reading reports, the firearm, first of all, there are 3 passengers in the vehicle. The firearm was found in a concealed compartment in the back of the vehicle that was closed. It says under the floorboard. I don't see how you'll be able to show knowingly, if anything, that he knew the gun was even there to begin with. It wasn't his vehicle. He was driving. There's no, again, it was in supposedly a concealed compartment. So I don't know how he was knowingly possessing or even aware that the gun was in there.
The court will find probable cause. The allegations on the charging document meet the elements to find probable cause at this stage. There's an allegation of possession of weapon with a prior, which is enough to meet the elements. The other facts are trial issues, so I will find that there is probable cause as to bond.
Your Honor, his father of 3 kids, employed at McDonald's. He's got numerous health issues, including suffers from seizures. Again, I would just reiterate, this was a firearm that was allegedly found inside a closed compartment in the back of the vehicle that was not owned by him, not operated by him. There was multiple passengers in the vehicle.
Was anyone else charged with the same gun?
Not aware, Judge.
Judge, I'm not aware of that. Preparing to that, I didn't see anything that appeared to be a co-defendant.
Is there anything else from the state?
Judge, just that his disability is noted where the prior robbery, he does have pending drug cases that have been indicted. It looks like he went out on a capious status in June of this year, and then does have a prior history of violence.
There are 3 prior violent felonies as an adult, 4 prior failures to appear. On the having weapons while under disability, 25,000 secured. On the carrying concealed weapons, 10,000 anyway. The improper handling, 5,000 anyway. The falsification. Do you want a nominal bond
Yes,
on that
Judge.
misdemeanor? 250 anyway on the falsification.
Your Honor, grand jury will be on 11/10. Lutz?
27, November 10th,
In here. Was he just in here recently? That's what I could say.
Good morning, Judge. What problem?
All right, that's the bond.
It's money arrest for MRs. These are 18 months old, Judge. These are from May 20th of 2024. Your Honor, the owner of the plate, Mr. Simmons, is very close friends with Mr. Lutz. They talk to each other all the time. Mr. Simmons indicated he's never reported a plate stolen, so they don't know how this warrant got popped up out of, I think it's from Morrow County is where Mr. Simmons lives. He'd actually given him the plate. Mr. Simmons put the plate on this, it's a trailer? Or sorry, camper, on a camper. Your Honor, no felony convictions, no fear to appears, Judge. That's according to my pretrial information, so I'd ask for one more bond.
From the state.
Judge, it's an F5 and a M2 and the M1. On that, we'll submit.
There's 1 violent misdemeanor, 3 misdemeanors, no violence, 0 failures to appear. These are 3 low-level, non-violent offenses, and they occurred over a year and a half ago. The bonds will be awarded.
Thank you, Judge.
Thank you, Your Honor. 11/13. Nelson, Tyler Nelson. There is a request for an order of protection. Michelle Edmonds. Michelle Edmonds.
Mr. Nelson is going to be signing the temporary protective order for the waive probable cause.
All right, pass the bond.
Yes, the bond. Mr. Nelson rather is 30 years old with no record other than traffic. That certainly said something about his likelihood of reoffending. He worked at Kroger's until about a month ago when he was laid off. Two notes on the charges. He's charged with falsification. And the proper circumstances, falsification might be relevant to his being willing to come back to court. The falsification is that he gave his name as Anthony. His full name is Tyler Anthony Nelson. That's his middle name. That's the name he actually uses. Secondly, with regard to the strangulation, it prints out as a felony 2. However, the section number 2903.18B2 is actually a felony 3. And we're not arguing about probable cause, but I think that is relevant to sentencing.
You do waive probable
We
cause.
do waive probable cause.
Is there anything else
That's all. Thank you.
from the state?
Judge, I would note it appears that there are 2 failures to appear in the last 5 years. As to the allegations in this offense, he is the father of the victim's 4-month-old child. They got into an argument, kicked her, punched her, and put his hands around her neck while she was on the ground. The victim indicated that she was not able to breathe while the defendant had his hands around her neck. And the allegation, at least, is that he gave his middle name and not his first name. He did indicate to officers that he did not tell them his name because he did not like police. Judge, as to bond, we would respectfully request a monetary bond, juris if requested.
Mr. Nelson's entire record consists of 1 misdemeanor. There are 2 prior failures to appear, no violence as an adult or juvenile. The questionnaire, the officers did not list any observable signs of physical harm. There is an allegation of punching and kicking. On the strangulation, it will be $15,000 anyway, plus juris if requested. On the DV, $10,000 anyway, plus juris if requested. Did he execute the TPO?
He did.
Judge, and or on the A charge.
Oh, what, yes.
Just
Oh,
we
what?
ask for not the bond on that, please.
You are not gonna bond on that. $250 at 10% on that anyway.
Your Honor, this will come back at 11:10. Owens? Owen.
Judge, it'll be not guilty on behalf of Mr. Owens, and we will be waiving probable cause.
All right, ask the bond.
Judge, as to bond, Mr. Owens is currently living with his mother. He is a significant help around the house to her, just with physical labor, chores that need to be done. Judge, he is currently looking for work. He's been looking for different construction jobs, warehouse jobs, any interviews that he can get his hands on, he's been going to. Judge, he does have a 1-year-old daughter at home. That's his main motivator right now, to find work, find stable employment, to ensure that she's financially cared for. Judge, I do want to note regarding the allegations, none of these are alleging any use of any weapons, threatening actions, anything violent. I do want the court to take that into consideration. Additionally, Mr. Owens does not have any failures to appear on his record. Judge, he has shown the court time and time again that he does come back for court. Judge, with that, we are asking for an OR.
From the state,
Your Honor, officers are requesting a high bond. I believe this all involves the same firearm. All these charges involve the same firearm. He was actually stopped by officers for trespassing. He was found in possession of the handgun after being convicted. He also was asked by officers and failed to disclose that he had possession of the handgun. Looking at his record, he does have prior violent felonies, aggravated assault. He also had felony drugs and at least 2 prior weapons under disability charges. Convictions, yes.
And Judge, I do want to note regarding the complaints that were filed in the police report, it does not state where the gun was located. The gun was not on Mr. Owens' person. Rather, it was inside of a backpack that was in a vehicle shared with other people.
Yeah, and would say that he did make a statement that he stated he bought the gun and carries it for protection.
Mr. Owens has 2 violent felonies, 3 felonies. There are 0 failures to appear. It looks like Mr. Owens was just released from prison October 1st. There are having weapons under disability convictions from 2023. The disposition date was 2024. The charge was 23, 2021. On the having weapons under disability, 35,000 secured. The CCW, 10,000 secured. The improper handling, 10,000 anyway. The receiving stolen property, the stolen gun, 25,000 anyway.
Judge, would you consider an alternate OR EMT lockdown for any of those? Understood.
Judge, and stay away please from the property owner on the RSP. Grand jury will be 11:10.
Stay away from the prosecuting witness on the gun.
Kyara Perkins.
Hey, Perkins, are you recommending sending the misdemeanors with?
They're going to go with it. Yeah. Looks like it all.
Would be stated again.
That's what I'm.
I'm showing it as all occurring on the same day, Your Honor. So.
Your Honor, I submitted Edel Gray's designation, the felony is appropriate for drug court, and Judge will waive probable cause.
I just want, if I press speak, please.
Hold on 1 second. Talk to your attorney first. Everything is being recorded and can be used against you at a later time.
I just want to go ahead and plead.
Okay,
Yes.
okay.
I just
So,
want my time, I want my family court, no none of that, no drug court, I just want to plead guilty and do my time, no probation, no nothing, and send me out to contempt.
she cannot accept a guilty plea today.
But that's what I want to do.
So, Ms. Perkins, today we're just here for a bond setting. Once it comes back from the grand jury, that will determine what the final charges are. Then at that point, it will go to a trial judge, and then you can work out that plea or trial, whatever you want to do with the trial judge, okay? All right.
Judge, yeah, and so we're asking the court for a nominal bond, yes?
Nothing additional.
There's 3 felonies, 8 misdemeanors, 4 prior failures to appear.
3 felonies, what 3 felonies are that?
The bonds will be on the possession 500 anyway, OR on the open container, on the soliciting, loitering in the drug paraphernalia, 500 anyway.
Thank you, Your Honor.
1110 for grand jury, it'll all go. Ruffin, DeMarco Ruffin. Right in the middle.
Good morning, Judge.
Yes. There is a request for an order of protection. Aisha Ruffin.
Thomas.
Well, Thomas?
Thomas.
Yeah,
Aisha
that's
Thomas.
what they had on.
Fair enough. Judge, we waive probable cause if I may be heard as to bond.
That's fine.
Judge, as to bond, Mr. Ruffin is executing that temporary protection order in regards to Ms. Aisha Thomas. Judge, I do want to note, I'm sure the court is aware from his records, or dispatch records, Mr. Ruffin has absolutely no criminal history at all, no domestic violence history, not even traffic tickets that I can see, Judge. This is a very much a one-off for Mr. Ruffin. I do have a solid address for him here local in Cincinnati. He does have 5 children. 3 of them he is on child support for, but all of them he is actively very involved in their life. He does see them week to week. It depends on the mother and what their schedules are. If they're able to compromise and find a good schedule coordinated so we can see all of his children. Judge, he does have a job. He works as a health aide. He is supposed to work this upcoming weekend, so he is at risk of losing that job if he were to remain incarcerated. Judge, with that, we would ask for an OR or an SOR bond.
From the state.
Your Honor, we respectfully, this is charged as an F3 and a DV. TPO is executed. We respectfully request a monetary bond, EMD, and juris if requested. It looks like TPO would take care of the firearms.
And Judge, I do want to note that he does not live with Ms. Thomas, so staying away from her is not going to be a problem.
As has been stated, Mr. Ruffin has no record at all as an adult or juvenile. He doesn't, have any dismissals. The prosecuting witness did fill out the safety questionnaire and stated that she felt safe in her home. The officer noticed a small laceration to inside bottom lip. There were no other things marked. The officer didn't mark any deadly weapons, and the officer did not mark that the officer believed that there was a present credible threat of physical harm if the prosecuting witness was released at this time. The bonds will be OR plus juris if requested with the TPO.
Thank you, Judge.
Your Honor, that'll be 1110. Singleton. There is a request for order of protection. Sarah Lacey.
Yep, in the middle of your attorney. Very nice.
For Sarah Lacey.
I did, Your Honor.
Wait, probable cause.
Yes, Your Honor.
Ask the bond.
Mr. Bond Judge, he's 30 years old, works as a software engineer full-time. I do got good contact information for him. He's executed temporary protection order, has no issue staying away. It's an OR score of 1, 0 failures to appear. Absolutely no record, Judge. My understanding, prosecuting witness was upset. She came at him. He was trying to calm her down. The 527 notes, it was a mutual physical confrontation where my client was trying to restrain the prosecuting witness. What he said, he was trying to get her basically to calm down. He had scratches all over his face, all over his stomach, marks all over his body as well. It's my understanding this was a self-defense situation where she was upset at him and he came at him physically. He was trying to restrain her. It has to the court take all that into consideration. Again, he has absolutely no record.
From the state.
Your Honor, I've just been noted that Ms. Lacy is present in court today. I don't know if she wants to address the court to bond or any other matter.
Did you want to say anything, Ms. Lacy?
Judge.
Come on up.
Ma'am, do you have your ID with you? Do you have your ID? You show that to the deputy, and then
Come
There's a-
around to this box,
there's
right?
a box right by the door. You gotta speak right into that so we can hear you.
Yes, ma'am. What would you like to say?
That is not what happened at all. I was asleep on top of him, and at some point I had rolled over, I guess, and I was on my back laying next to him. And then I was like half asleep, half awake. And he, I guess, rolled over to do Duolingo. Like he rolled this way. He then rolled on top of me once he was done and like got off of me and onto like the floor so he could shut the bedroom door and then to turn the fan on to go to sleep. And my hand was touching him because it's normal. Like I usually put my hand on his chest when I'm going to sleep and like we fall asleep that way. He got mad at me for doing that. And so he rolled over. I put my hand on his back like normal, thinking everything was fine. He got aggressive because of that and got upset at me because of all of this. And I was so like confused as to what was going on because I just woke up. I was so confused. So I'm trying to talk to him and he kicked me off the bed. He put his feet on my stomach and kicked me straight up off the bed. And then I'm like, what the hell was that for? Like, I'm like so confused. I'm still like, how, like, what is going on? So I'm trying to talk to him. I'm trying to rub his back and everything and like calm him down. I tried to hug him. He kept shoving at me. And I smacked him because I was like, stop. Like, I don't understand what is going on. I'm so confused. And so from that on, he then kicked me again. I don't remember how exactly, but I guess my face was towards the foot of the bed and my feet were towards the head of the bed. When he kicked me that time, I rolled over on top of the nightstand. And this happened to my ankle. And I have another mark on the other ankle too, because I guess they both hit the nightstand. And I was like, what the heck? He then proceeded to come at me, beat me with a pillow on top of me. And he proceeded to say, you're abusing me. He then went I don't remember what happened. I think I may have scratched him at this point because I was like trying to get him away from me as self-defense because I was terrified of what was going on. And so he then choked me and put my hands behind my back like this, and he was pulling at my arm like this. And as that was going on, I was scratching at him because I was trying to get away. I was trying to get him off me and he was choking me, and at one point I could not breathe. And I was trying to tell him, I can't breathe. That is why I have this scratch on my neck and marks on my neck. And furthermore on that too, I went in, like, I saw him go into the bathroom, look at himself because he was marked up, because he was upset at me for doing that, for defending myself. He proceeded to call a domestic abuse hotline. I thought he was calling the cops. Like, I thought he was on hold with the cops to tell them that I abused him. So I was like, what is going on? So when I went in to finally go into the bathroom to address my wounds, he was coming into the bathroom, yelling at me, screaming and hollering at me. He finally decides to like go and leave me alone, and I finally was able to lock the door to the bathroom. I had called the cops. As I was calling the cops, he was trying to get into the bathroom door and unscrew it with a screwdriver.
Do you, thank you. So he's executed a protection order to stay away from you, all right? So he is to have no contact whatsoever, no call, no text, no email, no social media, no contact with third parties. Are you concerned for your safety? I see that you filled out the safety questionnaire and that you were concerned that he would seriously harm you or kill you.
No,
Are you still concerned?
no,
You're not concerned?
no,
Are you concerned at all for your safety?
partly yes, partly no.
Do you want Juris Monitor as a condition of any bond? That means that he would have a 3-mile radius from your home or place of work.
No.
All right. Thank you, ma'am. Is there anything else from the state?
Judge, I'm noting the information. It looks like there were a couple of different mechanisms for the strangulation. One, she told deputies that there was wrapped his hand in a C formation around her neck, and then at another point, in an effort to restrain her, got her in a chokehold or headlock.
As has been stated, Mr. Singleton has no record, no failures to appear. He has executed the TPO. I did not ask this. Do you have a request on a bond outside of Juris Monitor?
Are you asking me like what I feel that it should be?
Yes, do you want a monetary bond? You already said you don't want like an or do you want electronic monitoring? You don't want Juris, but are you requesting an EMD or some type of monetary bond?
No, I would like him to try to get maybe some anger management or something because I honestly think he needs it. He feels that if, obviously you can tell I'm upset right now, so probably my voice is a little bit raised than normal. He gets upset about that. And then that gets him angry and aggressive.
All right, thank you, ma'am. And he has somewhere else to stay, correct?
Yeah, sure. Well, Your Honor, he said he can stay with his mother.
I'm sorry.
Mm-hmm.
I know this is asking a lot. I would like to remain in contact with him, and I would like to remain living.
Right now, he's executed the TPO, so he is not to come around you at all. No calls, no texts, no email, no social media, no contact through third parties until further order of the court or until this particular case is resolved. All right? He can return, did you check the box so he can return with the police escort to get personal items during the pendency of the case?
We would be
Does he-
requesting that, Judge. Thank you.
You can check the box.
If I may, I just want to get some information from the victim.
Yes, based on what the prosecuting witness has stated, the lack of record, the prosecuting witness not even wanted the TPO, but Mr. Singleton did sign it. I'm going to set an OR bond.
Thank you, Judge.
Judge, and for the TPO of firearms.
Yes, that is a
What's the
for
grand jury?
DVT.
Grand jury date will be.
Sorry, Judge.
That's it.
Yep.
Go.
Get out.
Coming. Well, just get up while you're turning first thing. All right?
11:10. Next will be Slayback.
Thank you, Judge.
No, Mrs. King, you're turning from the other line.
Good morning, Judge. Yes, Judge, we not guilty on behalf of Mr. Slayback. Judge, as to
Oh, well,
bond.
hold on one second, I'm sorry. I didn't realize.
Oh, I'm sorry.
The prosecutor's still working with the prosecuting witness in the evidence. Sorry about that, I didn't realize you were still over there. All right, ask to bond.
Judge, as to bond, we are going to be asking the court for an LR bond. Mr. Slayback has no failures to appear, a very low risk assessment score of 2. Judge, he does not live with his prosecuting witness. They actually don't live even remotely close to each other. The prosecuting witness stays over in Mount Washington. Mr. Slayback stays all the way out past Kettering in Gettysburg, Ohio. His fiance is currently in Kettering Hospital. She did have a stroke. Judge, that has left Mr. Slayback with all of the household responsibilities, handling all the bills, making sure the house is clean, laundry is done, food is cooked for the children. Judge, he does have one child in common with this prosecuting witness. However, he does have 2 sons outside of this prosecuting witness that he does have contact with and that do rely on him for support. Even outside of just the child support, the financial obligations. Judge, Mr. Slayback did just get a new job. He's been a mechanic for about 22 years, but he just started with a new company over at Express Pro. If he does not make work, he is at risk of losing that job. Judge, again, based on the distance between his address and the prosecuting witness's address, there will not be any contact going forward. Again, 0 failures to appear, so he does show up for court, Judge, and he does have other family that's going to keep him accountable and be another set of eyes and ears on him at all times. Judge, in the alternative, we are going to ask for an OR EMD plus juris. Judge, that way the court has assurances he will be staying away from this person and he will have extra court supervision placed on him.
From the state,
Your Honor, this is his 3rd violation in 2 years, looks like 2 years. And we recognize this was apparently emails to the phone. However, it does not appear he is going to, that he's going to comply. And so that is our concern. We would respectfully request a monetary bond and juris if requested.
there is 1 violent misdemeanor, 4 misdemeanors, 0 failures to appear, 2 prior violations of a protection order, the same protection order, 10,000 secured plus EMD plus juris if requested.
The grand jury will be 11:10. Next will be Isaiah Smith.
You may want in the middle and you're turning to the other way.
Your Honor, we will waive probable cause. Regarding bond, Mr. Smith is 27 years of age. The only record I'm aware of is a minor misdemeanor, which I think is a drug paraphernalia. He does work full-time at Spaghetti Factory as a server. He's had that job, full-time job for a year. He has a 2-year-old daughter. He has a shared parenting agreement with her. This is a situation that was the end of a physical fight in which followed the prosecuting witness threatening to shoot Mr. Smith. We asked for a relatively low bond or even an LR. Thank you.
From the state,
Judge, it looks, this arose out of a fight. He stabbed the victim with a knife. Looking at his record, it does show that there's 1 failure to appear. It looks like that may have come out of Covington about 6 years ago, 5 years ago. Or there was one 6 years ago, there's maybe another one that's showing up within the last 5. It's F2, we respectfully request monetary bond, jurors if requested, and no weapons.
Is there anything in the state's record as to the injuries?
Judge, it just indicates that the PW was stabbed.
Do you have anything, was the PW transported?
It does not give me that information as to whether or not they were transported or if they were treated or how they were treated.
Judge, one of the things, Mr. Smith is telling me that once he was aware there was a charge against him, he went to the police to cancel it, and it's certainly relevant to the loan.
Would say this does appear to be a switchblade knife is what they've listed in the complaint.
Mr. Smith has no record except for one minor misdemeanor, one prior failure to appear. This is an F2 stabbing. It looks like during the fight. And the parties are apparently unknown to one another. There's nothing in the record about injuries. If anyone had to go to the hospital. The bond is $50,000 at 10% plus jurors if requested.
Your Honor, that will be 1110 for grand jury.
Sturgeon.
Sturgeon.
She's got it.
Your Honor, I'm submitting Edel Gray's designation for Amanda Sturgeon. We'll waive probable cause. Thank you, Judge. She is 48 years old. She's been in the Hamilton County area for 5 years. Has her GED. I show no felony convictions from what I can see anywhere. And I believe the most serious charge before you is a 5th-degree felony. Unfortunately, I can't provide an address, but we do have a good phone number for her. And she is going to be offered treatment.
From the state.
Your Honor, it's F5 possession. Looks as if they're calling it crack or cocaine. And an amount that is, they have it less in bulk, so it makes it an F5. The falsification and the illegal possession of drug paraphernalia will also go with that to the grand jury.
Your Honor, if I may, for the city,
Yes.
the theft offense, it looks like a new one, so I need to stay away from Target. Alleging $172 worth of value.
Is that the case sitting at 942?
942 case, yes. And then there's one coming out of a KPS status, so failures to appear are apparent in that one.
There are 7 misdemeanors, 2 prior failures to appear. I'll start with the KPS bonds. The assigned judge for Ms. Sturgeon on the misdemeanors is Judge Berkowitz, and he has set bonds after a capias in his room or a bond revocation. He had set a capias in his room from back in August. I will not change the trial judge's bonds, so those bonds will remain the same. They are $2,000 anyway. So knowing that Judge Berkowitz's bonds are in place, do you want nominal bonds on the other charges?
Yes, Your Honor.
On the theft, well, on all of the misdemeanors and low-level non-violent felony, 500 anyway.
Thank you. 1110,
And there's a stay away from charges that.
Yes, stay away from target on the new theft.
Thank you.
Joseph Thomas. The traffic will go with
Joseph Thomas.
With the felony.
Yeah, I'm sorry, there are a couple of, the traffic ending in 27804 will go with the felony.
And on those cases, the felony and the related traffic, I'm submitting Lauren Thompson's designation and then John Valentik's designation for the unrelateds. Waive probable cause.
Ask the bond.
Your Honor, I think the most serious charge before you is a 4th-degree felony. He is 36 years old. He's a graduate of DePaul University. I show he is working for a Provisions Mart, so I was hoping to keep that job, Your Honor. We asked the court to set a low bond.
From the state.
Judge, possession of F4 cocaine, he does have pending felony drug cases. He also, I would note the capias history.
From the state, or from the
So
city.
thank you, Your Honor. I mean, there's obviously failures to appear here with an OBI pending. We have concerns with drugs, serious drugs, like random screens, if that's a factor you could use for the TRC case, along with whatever you think is appropriate to get him back to court.
So on the OBI that is pending, there's the OBI series from May. Judge Janacchio said capias bonds. I'm not going to change Judge Janacchio's bonds on her cases. She's the trial judge. I've experienced with Mr. Thomas, so those will stay the same. On the new possession, I'll do a nominal bond of 500 anyway, plus randoms. And then on the driving under suspension, that will be OR.
Could we consider an R in the alternate?
For Judge Janacchio's bonds?
Yes.
1110 for grand jury. Gary Thompson.
Judge, we're moving to waive Mr. Thompson's appearance,
Waive probable cause.
waive probable cause, and I'm submitting Amy Duddish's designation. She represents on a case that's currently before Judge Wagner. But he's been held since October 8th, and we're setting bond on a 5th-degree felony for him, Your Honor, so we'd ask for a low bond.
From the state.
But it looks like he's got a pending vandalism, felony vandalism, pending assault.
Are these related?
Not to this, they are not related. They seem to be 3 separate incidents. I think Mr. Thompson is sort of well-known as being fairly aggressive and
$2,500 anyway, plus a stay away from the Mercantile Apartments.
grand jury will be 11:10. Colbert.
Right in the middle, there's three other ways I can go talk for you, okay?
Yeah, we will waive probable cause. Regarding bond, I recognize the seriousness of the offense, and I see that Mr. Tolbert does have a prior record. He is getting SSI, he has a doctor's appointment on Monday, both for diabetes and a mental health situation. He would have only a very minimal amount for bond. Thank
From
you.
the state.
Your Honor, we are going to be requesting in total $50,000 secured bond. Looking at his record, it goes back, he's got a number of, at least 2 violent felonies. Those involve a sexual battery and a unlawful conduct with minor, as well as a number of failure to register, so that would be concerning about losing track of him. In addition, in this case, I have received information and a great deal of it in that the defendant approached the victim in the Blue Ash Kroger parking lot, asked for money. The victim declined to give him money or was unable to give him money. He then opened his jacket and produced or showed what the victim believed at that time to be a handgun, and then had him go back into the Kroger to the ATM machine, withdraw approximately $200, which he actually took out of the ATM machine, not the victim. He wanted to withdraw more. He, again, declined, and then he left. So the conduct that we have here seems to be a continuation of his behavior that has been well established for quite some time. It does appear that his most recent conviction was about 2 years ago for an aggravated assault, which is another violent felony. We, in addition to the monetary bond that we've requested, we would also request stay away from all Krogers, stay away from no contact with the victim.
There are 2 violent felonies, 2 felonies, 3 misdemeanors. It appears, as the state said, that Mr. Tolbert was released from prison about a year ago on a violent felony. On the kidnapping, 100,000 secured. On the robbery, 100,000 secured, plus jurors if requested on both if the monetary bond is made.
And just to stay away from the Krogers as well as the, well, the jurors for the victim would be taken care of by the, but stay away from Krogers.
11:10. Waller.
Good morning, Judge. Right
Good morning. Esteban.
Esteban, Your Honor, I understand it's a serious allegation. Law understands that. Your Honor, denies taking a gun or pointing a gun at anyone. Your Honor, it's my understanding that the alleged victim is a woman that Mr. Wall was dating. It seems to be stemmed from an argument over some perceived infidelity on Mr. Waller's part. Your Honor, we're just asking for a reasonable 10% bond. Yes, we consider 75,000 at 10% or 50,000 at 10% with EMU. He'll stay away and have no contact with the young woman. Again, Judge, I don't think this is going to get past grand jury. Again, he denies brandishing a firearm, taking a firearm. I don't believe the firearm was recovered from him. Looking at Luxford judge, so he understands that there will probably be some kind of bond of this, and we'll take that into consideration.
Judge, the firearm, I believe, at issue, which is the Sky CPX-1, it's a 9mm firearm, once in his possession, and was pointed at the victim's face, which is concerning. I would note that his capious history, as well as there appear to be violations of protection order, but there also seems to be, there is a prior conviction for felonious assault. So we would request monetary bond, EMD juris, stay away, no contact, and no firearms.
There, 1 prior violent felony, 3 misdemeanors, 9 prior failures to appear. On the aggravated robbery, 50,000 secured plus juris if requested. On the driving under suspension, OR.
Your Honor, I don't have the file, but I think we do. Although she just stepped off as soon as I say that.
You all worked out a plea on this?
Well, Your Honor, I think the 4510.11 is really a 4510.16 due to a scrivener's error. It actually supported on the citation itself with NC non-compliant suspension. That's 4510.16, making it unclassified. I'm expecting a guilty after the amendment on that, and I'll move to dismiss the stop sign for the plea. There was no crash. There's also no insurance. I think that's a guilty plea.
Mr. Waller, a guilty plea is a complete admission of guilt. The driving under suspension as amended is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to 1 count of driving under suspension?
Yes, ma'am.
All right, I'll accept the plea. Counselor, do you waive the stipulate?
Yes, Your Honor.
That includes waiver of service of a new complaint and arraignment of the amendment.
Yes, Your Honor.
Finding guilty. Mr. Waller's been in for 1 night.
Yes.
All right, is there anything else as to mitigation?
No, Your Honor.
Is there anything else from the state?
Not on that note.
Mr. Waller, did you want to say anything as to sentence? You have the right to, but you don't have to.
What far as the trafficking ticket?
Yes, sir.
Oh, no.
1 day, credit 1 day, remit the fines and costs, FRA non-compliance. As to the bond on the criminal damaging, it looks like the trial judge has not set a bond. These are magistrate's bonds, so I will review them if you want to make a bond argument as to the criminal damage.
We would just like a nominal bond, Your Honor, and like the felony charges.
If it doesn't say already, continue to stay away from Daisha Bruce.
Bond 250 at 10%.
Where's the grand jury report date?
Grand jury report date on Mr. Waller will be 11/10, and that's just on the 5th.
From the felony.
Zeister, Kenny Zeister?
Your Honor, on Zeisler, we're moving to waive his appearance, and for the record, Dan Might standing in for Donna Denham. Oh, I guess. Zeisler? Oh, what's your name? Okay, this is not Mr. Zeisler.
Is Zeisler present?
No, I was correct that they sent him back upstairs.
Okay.
So,
Is this gonna be tomorrow or?
no, Judge, we can proceed because, Mr. Zeisler already has counsel.
Okay.
So, and, if I could seek clarification briefly from the state, he's been held since, September 26th, but this charge allegedly arose yesterday. So I'm assuming, was there a search warrant of his phone in the jail?
They recovered images off of his phone of a child in the state of nudity.
While in the jail?
So it relates to his pending importuning charge.
So, Judge, obviously he hasn't been able to make bond on the case that's already set. This is a 4th-degree felony. We'd ask for a nominal bond.
From the state?
Your Honor, as noted, it appears that this is a result of a search warrant from the phone that was recovered after his arrest. It looks like the search warrant would have been executed if he was arrested on the 26th of September. It looks like the search warrant was executed on or about the 30th of September, and they recovered those images. It looks like he was served with this yesterday.
$15,000 secured plus the stay away from any non-related persons under 18 years of age.
And 1110 for grand jury.
Is this Ms. Beamer?
Spielheimer.
There are no felony warrant instructions.
Caleb Ethan Garcia, practicing on my limited license under the supervision of Michael Welsh.
Lavelle Beemeyer?
Your Honor, I could continue. Your Honor, I'd just like to briefly draw the court's attention to the affidavit in today's case. I understand the complaint has pretty basic language on it. The affidavit itself states that this was an accidental contact that was made with a prosecuting witness in this case. And so I don't think this actually qualifies under the A or the B section of the domestic violence statute. There is no allegation of any type of physical harm to the prosecuting witness. And the prosecuting witness stated that this was an unintentional contact, which wouldn't be enough for the A or the B section. Your Honor, Ms. Beeheimer has zero record, not even a speeding ticket, therefore zero failures to appear. She runs her own dog grooming business. She has appointments today and through the rest of the week, which helps her sustain herself. We would be asking for an OR bond. I have every reason to believe that she'll come back to court and stay in contact. This is her husband, who she's been with since she was 15 years old. She's not willing to sign the temporary protection order because they have pets together, they have a house together, they pay bills together. I don't anticipate this being a reoccurring issue, but a scuffle. We'll be asking for an OR.
Judge, if she's unwilling to sign the TPO, we'd ask that be taken into consideration for purposes of bond. We'd also ask that we set over tomorrow for a TPO hearing so we can notify the PW to be there.
Sorry, Governor, I also do have a different address if that's the court's preference that she stay somewhere else.
Was she signing the TPO or no? If she's not, then we'll have the hearing going tomorrow. If she is, then there's no need for a hearing. In the interim, I will order jurors right now so that the prosecuting witness would be notified prior to her release.
She's going to sign the order, Your Honor. We'd ask in light of the order that she be allowed to go and retrieve her clothes and other things.
Check box 13.
Box 13.
Will you check it?
Judge, we respectfully also request, it seems that alcohol was at issue in this particular instance. No alcohol is part of the bond.
With the TPO executed, the bond will be, so the defendant has no record at all as an adult or juvenile. The bond will be OR plus a TAD unit and no alcohol. I have put on here for the TAD unit to be put on today so that she can be released today once the TAD unit is on.
Thank you, Judge.
Okay, Corey? And there is a request for an order of protection. Kautor Barga?
Not guilty on behalf of Mr. Corey. He has qualified as over income, so I'm not able to designate. We will track the case. He is willing to sign the temporary protection order. So, sign there. He is signing that right now. Regarding bond, he is 37 years old. He has no prior anything. He works for M&M Metals International. He's been there for 10 years. He's a general manager, also does sales, manages about 10, 11 people in a warehouse. He is not going anywhere. He is not a flight risk. He is not a risk to the community. We are simply asking if the court would consider an OR bond, check box 13, so he can get items, and we'll go on from there.
Box 13, can you check
Thank you.
from the state?
It looks like the report says that officers did observe visible injuries to the chest area. And I'm noting on the victim sheet, she does want a protection order. She does want juris. And
You said she does?
she does want juris is what I'm reading here.
I don't think that's necessary, and it would put his employment at risk.
So we respectfully request monetary juris as part of the bond.
The bond is with no record, no failures to appear. He has executed the TPO. The prosecuting witness has requested juris. I will put juris on, based on the request, OR plus juris if requested. I would ask that the state get this information, or I don't know how they do it, Because without the request, I would have done an OR with the TPO, so I don't want him to be held for 3 days while they try to contact her. So I just want this information to make its way quickly to, EMD.
Joe, do you want him out today to report to go get EMU?
Well, it's a jurist.
You want him to report?
So that would be pre-trial,
Mhm.
set up the jurist.
No, it's EMD. He
EMD.
sets it up. I
Right.
just want the contact information for the prosecuting witness to be, sent over right away so that he's not waiting for them to contact for 3 days. Thank you.
Yeah, I'll get rid of that too.
Okay, thank you.
Oliver, you go.
I got it. I just didn't know if you wanted him to walk over. I got it.
Okay.
Last hallway.
Garnett,
10 minutes, we're gonna have to try this.
Garnett is next.
Actually, bring him back out real quick.
She wants to back up.
Oliver, she wants him back out.
Bring him
Mo, send him back.
Oh, hand me that, please.
Mr. Hickalooper, recalling Corey.
I heard.
Okay,
Stack of film there, so.
fair enough.
Get ready to go. Corey?
So instead of jurist, I am doing EMD with a 3-mile radius. It has the same basically effect. The prosecuting witness can add jurist later, but if he goes within the 3-mile radius, then it will operate the same as jurist so that defendant can be released today. The reason I am doing that is, as I said, without the specific request for the radius, the court would have done an OR bond. There's no record, no failures to appear. There's no dismissals on DVs or anything violent. And the allegation is pushing. There was not allegations of striking, of weapons. It was pushing, which are at this point are just allegations, but based on the history, verified employment and those things, this court will do OR, EMD, open hours with a 3-mile radius.
Yes, you can still,
Yes,
yes, you can still do that.
But they have to verify. I don't think Ian's gonna get him, this is where I'm getting. They already have a list of criminals and traits in front of them.
Would this be?
Unless you want him to walk.
Well, just, probably the first one.
I see.
Friends or family.
Can we, he does not have any friends or family who lives in Ohio. The closest relative is his mother who lives in Louisville. There's not really a place where he would be able to go on E&B or to be able to go. His plan was to get either an Airbnb or an extended stay hotel while this was pending.
They allow that. He just has to pay up for a certain period of time. I want to say it's like a minimum of a week or 2 weeks.
I understand that. Then creates an issue of how he would do that from inside the jail.
I'm sorry.
I'm not sure how he would do that from inside the jail.
He can go to Kentucky with jurist.
And not.
Because he won't be coming back into that zone.
If the court specifically allows out of state, he can go to Kentucky, but he'd have to go to Louisville, and I don't think they'll let him go to Louisville. This isn't like Covington.
They will.
Yeah.
My issue is not tracking him here. It is to make sure he doesn't go around the house.
I understand.
So it will work if he comes back in town and goes within that radius. So he can go. Now he will have to come up if there is a need to calibrate or do something with the EMD.
Okay.
So would it be simpler to go back to jurist? Since that's a zone of prohibition?
Well, the EMD with 3 miles is going to be the same.
I understand.
The issue is, and I realize I'm being a pest about this, pretrial services will not release him on EMD until he verifies an address, and it's not just him coming up with one. Some third party has to call in to verify, yes, he's really staying there. And I don't know if there's a way to facilitate that. And
There
then he's
is.
essentially held on no bond.
There is. He has to, and it may be, someone from EMD comes over to get him and takes him over. And then if he has a credit card or something on him, he can book the, hotel or the extended stay for however long, or verify with family where he's staying in Kentucky.
Okay.
So, but I'm not gonna take it off because it was specifically requested by the prosecutor.
Right, and I understand that we're talking 6 and 1/2, half dozen the other between the two, but I was wondering if the Juris one would be simpler to accomplish that same purpose in terms of him being able to. Okay.
Because if she really wants Juris, then he has to be on EMD. You can't have
Gotcha.
Juris without the EMD, so this is gonna be the same either way.
Okay. I'll extra it.
So we'll,
Yeah, I'll extra it and have them work on it fast.
thank you.
I hate to call your mom on WhatsApp.
Oh, no, you're fine, thank you.
Health services to try to provide status. I just know I was administrative paperwork, so someone doesn't.
No, tomorrow's fine, because it seems like they need to work out some logistics, so.
Yep, I will give it to Jim, we'll extra it.
All right.
Close the bell.
Garnett.
Cool, thank you.
Nadine Smith.
Ms. Smith,
Alright.
do you have your ID, Ms. Smith?
Yes, during the whole like discrepancy, my purse or wallet was stolen. You know, there was like a lot of stuff going on, but I do have like a picture of my ID.
That's fine.
I'm sorry? Oh, that's.
He's old.
These glasses. Hey, wait a minute, so am I.
All right, Ms. Smith, what would you like to say?
Yes, I would like to say that Mr. Garnett, he is directly related to the arresting officer. And she had just like arrested him probably like last month or the month before on the same offense. She has no proof, no evidence. She just like, if they have a family, you know, discrepancy going on right now, and she brings that into her work. So I guess when she heard the call, a neighbor had called, we were kind of getting loud in the apartment. There was no physical contact between the two of us, and I can, you know, I have people that can vouch for that. My children were in the house, they were asleep, like it was no, you know, it was a regular morning. There was no discrepancy between the two of us at all, no altercation between me and Mr. Garnett. When she knocked on the door, it was supposed to be a welfare check. So I, you know, naturally came outside, and it's his cousin, and I've known, you know, this family for a long time. So I came outside, and she automatically, she tells me, you know, you've got something on your neck, you've got bruises. As you can see, ma'am, I'm not harmed, I'm not touched, I'm not afraid for anything. I think that what they have going on in their family, they just experience a death, and it's just a lot of like, you know, every family goes through their things, but we're suffering because of his personal or her personal vendetta against Mr. Garnett. The arresting officer, her name is Lachelle Garnett. They're literally like related, and they're dealing with family issues, and we have to like suffer. My children and I have to suffer. She threatened me to call 2-for-1 kids if I didn't, you know, say certain stuff. She's winking at me like, yeah, like when they detain him, she's like telling him to calm down because they're detaining me too. And she looked at me and winked at me like, I don't know, why are you winking at me? Like, you know, so it's just like a lot of personal things bleeding into professional work life. So, and it has nothing to do with me or my children. And I don't like that we keep getting dragged into this. I filed a report with Mount Healthy Police Department because I'm just tired of this. This is the second time.
Are you, and I have to ask this, are you concerned for your safety or the
No,
safety of your children?
No, ma'am.
Do you want a protection order?
No, ma'am.
Has anyone threatened or coerced you to be here today?
No, ma'am. I feel like I was forced to, like, she tried to threaten me with 2-for-1 kids, but she tried to force me to say that he actually did hit me, and that was not the case. You know, so
All right, thank you, ma'am.
you're welcome. Thank you.
From the state,
Judge, I don't see Officer Garnett anywhere in this, in my paperwork at least. I would note that in the affidavit, it resulted in a 3 to 4 inch bruise on the left side of Miss Smith's neck, or excuse me, left side of Miss Smith's cheek, and on either side of her neck. She
when did
is,
this happen? Is this allegedly yesterday?
this is allegedly yesterday.
She was, have a seat, have a seat, it's fine.
It'll be okay.
Okay, I'm sorry.
You're fine.
I understand what is on there. She's standing here. We're a little bit away from each other, but I don't see any bruises on her face or neck. She has stated that it did not happen. She doesn't want anything. There's no allegation of a weapon. The bond will be a supervised award.
Thank you.
Judge, I don't know if it'd be in everybody's best interest if there's a stay away during the pendency of this.
Why?
I'm not gonna order the sale.
One
All
officer.
right, have a good day, sir.
Jenkins?
Well, you're attorney, right? No way.
And Your Honor, these are not guilty.
All right, ask the bond.
As to bond, Mr. Jenkins, so this was, these two complaints are from 12/8, 12/9. He wasn't cited until I believe yesterday. And so I do believe that there is going to be a Sears motion here. He does have a job lined up with doing demolition work for a person that he's worked for before. He does have a good address with his fiance. We are asking for an SOR in this case. Trying to stay away from Lowe's while the case is pending.
Judge, that's what we're asking for, to stay away from Lowe's.
Was there a holder and he was brought here from Claremont County?
I think he had just completed something in Claremont County, and so yeah, that is how he got here.
Did he come here himself or did they transport him here?
They transferred me here, Your Honor, from Claremont County.
I'll do OR, I am doing EMD open hours. There are 36 misdemeanors and 9 prior failures to appear. So it'll be EMD, but it'll be open hours. All right, Thompson.
Good, good. No, I'm ready, no worries.
Evening, Your Honor.
Good afternoon, or.
Afternoon, I'm sorry.
Good morning.
Get in the cave.
Good morning, Mr. Thompson.
And Your Honor, the plea is not guilty.
All right, ask the bond.
As to bond, Your Honor, Mr. Thompson, so I usually don't like to get into the facts too much, but I am going to address some of it. This is an allegation from a neighbor. Mr. Thompson, he had heard his neighbor basically calling out for help. He had gone to basically check on his neighbor. There was, I guess, a lot of emotion in incident. He did call 911 in this. He has 0 failures to appear in the last 5 years. He has an arrest for 2. He has a GED. And Your Honor, I would just note that he is indigent at this time.
Hold on for 1 second, Mr. James. All right, if you want to say something, run it by your attorney first, because everything here is being recorded and can be used against you later.
Yes,
So
ma'am.
a lot of times it's best to just speak to your attorney, okay?
Yes, ma'am.
All right,
It's impossible for me to,
hold on for 1 second. Say what you want to say to her first, and then you all can decide.
I work at the food pantry on Thursday. I unload the trucks. I missed my work today. That's bad. It's all I got. I've been on parole for 12 years. I haven't been arrested in 6 years.
And Your Honor, he wanted me to just share that he may have been confused as to where the call for help was going. He has informed me that he does have a hearing impairment. And so, but I did talk with him about a stay away, no contact as well. He said that he usually goes, I believe this neighbor lives upstairs, and so he usually goes in through a different entrance.
Separate
and-
entrance,
Yeah, and so
I never see him.
It's informed me that it would be possible to have a no contact, no stay, or a stay away, as he can go a different exit.
I won't hurt Mr. Medeiros. I was checking on him. I was trying to
1
help him.
second. Don't get into the facts of the case, all right?
Oh,
From the state, is there anything from the state?
Judge, I'm looking at the history here. It does appear that he's got a number of violent felonies on his record. The allegations are a little bit different in that the PW alleges that the defendant was banging on his door with a knife and a hammer in an attempt to get him to come out and fight, which is what caused the fear of serious physical harm. So we would certainly request stay away, no contact. The jurist would be appropriate in this case with the PW if that's requested.
And Mr. Thompson contacted the police? There's 0 failures to appear. There are 4 prior violent felonies, the latest of which actually he got released in August 2024. He's the one who called for the police. It'll be OR plus stay away, no contact with the prosecuting witness, plus no weapons.
thank you.
Right, thank
I
you,
won't hurt
Mr.
Mr.
Thompson.
Medeiros.
Trayvon Wade.
Or. Oh, I was, yeah, they don't want to say that. She got her turn. You want to do
Is the city prosecutor's going to?
They have a statute.
You see the city prosecutor.
Looks like there's a couple. PDs.
No luck. It's not there.
Okay. Judge, the new case is a county case. It's a, looks like it's a 12-point suspension letter, suspension. Insurance was not shown.
Is this a good 12 point?
I'm sorry,
Is it a good 12 point? Have you looked at the,
I don't have his BMV available to me. Going by what's on the ticket. And then, like I said, FRA is no.
Esteban?
Esteban, Your Honor, Mr. Wade, so he does have several probation violations. In speaking with Mr. Wade, he had gone to the hospital at about the time that he stopped reporting. He had intense chest pains, and I believe that he had been hospitalized for
Yeah,
about,
what I'm saying.
like, it was a chest issue. Heart problem. And he had been hospitalized for about a month after he had gotten out of the hospital. He did try and get in contact with his probation officer, and he was not able to at that time. I did look at the judge's sheet. I didn't see a bond set on any of them, and so we are asking for an SOR or an OR EMD with open hours in this case. We are going to connect him with our social workers in our office just to start addressing some of the things that he originally was supposed to be addressing with probation. And in speaking with him, he did do a remedial course for, I believe, traffic, and so I'm not sure where his license is. He is planning on getting a valid license, and so I'm going to direct him to the room 167 as the experts in that. But I do think that he is planning to work hard on all of this, and we would just submit on that, Your Honor.
From the state?
Your Honor, as to the county matters, there is one new matter that is the license suspension, and it looks like there's an outstanding PV. We just asked that the PVs be sent over to the trial court.
On the probation violations, it's OR plus EMD open hours. It's actually the same on the license suspension letter. Well, no, that's traffic. I'm doing OR on the traffic. The misdemeanors probation violations will be OR EMD open hours.
Judge, it looks like you have one walk-in. Kevin Bush? Kevin Bush in court? Sir, come up to the door, the deputy will let you in.
This is standard line.
Yeah.
Yes, one more. Holiday, hey. Thank you.
Good morning, Mr.
Good morning.
Bush. All right, so it looks like last night you paid a standard bond of $1,000 at 10%. That bond will remain the same. You will go get a new court date, and then you need to contact an attorney prior to that court date, all right? And
Okay.
they'll give you the information. What's the?
117.
117. You go out that door then, okay?
Okay.
Thank you, sir.
Thank you.
They just need a time for tonight. 7?
That's it. Dan said that all our 10:30s are done.